Good morning, everybody. We'll go on the record here in Bingham County. It is December the 29th, 2021. This is case number CR 0621-6435, State of Idaho versus Craig Rowland. Present here in the courtroom, I have Mr. Olison, who represents the defendant. Mr. Rowland, I have Mr. Nye, and who do you have with you there, Mr. Nye?
Your Honor, this is Jessica Keene. She's the prosecutor for our office.
Good morning, Ms. Keene and Mr. Nye.
Good morning, Your Honor.
This is the date and time for an initial appearance of the defendant, Mr. Rowland. This case came before the court approximately a week ago via Zoom. At the request of the defendant, the court rescheduled the initial appearance so that we could do that here in person in Bingham County. Mr. Olison, are we prepared to proceed today?
Yes, Your Honor.
Mr. Olison, it's my understanding that your client has seen a copy of the criminal complaint. Is that correct?
Yes, Your Honor. He's reviewed it. His name is accurate. Everything else. And he understands the allegations against him.
All right. And it's my understanding your client is waiving a formal reading of that criminal complaint here on the record?
That's correct, Your Honor.
Your client has also filled out a notification of rights form. Is that correct?
Yes, Your Honor. I believe that's been e-filed.
I've seen a copy of that. He's waiving his rights to have those rights read to him here on the record today. Is that correct?
That's correct, Your Honor. He understands those rights.
We'll proceed then with just a summary of the criminal complaint. Mr. Rowland, you filled out a notification of rights form prior to the hearing today. Is that correct?
He did, Your Honor, and he is exercising his right to remain silent in this hearing today.
Thank you. Mr. Rowland, you have been charged on a criminal complaint here in Bingham County, Idaho, in this case number. It charges you with 3 different counts. The first count is aggravated battery, a felony, a violation of Idaho Code 18903A and or B, 18907B, and or 18908. That charge carries with it a maximum penalty of up to 15 years in the state penitentiary, a $50,000 fine, or both. It also carries with it the potential for restitution. Count 2 is aggravated assault. That is also a felony, a violation of Idaho Code 18901B, 18905A, and 18906, punishable by up to 5 years in the state penitentiary and or a $5,000 fine. You could also be ordered to pay restitution on that count. Count 3 is a charge of exhibition or use of a deadly weapon, a misdemeanor, a violation of Idaho Code 183303. That charge carries with it a maximum penalty of up to 6 months in the county jail and or a $1,000 fine, or both. Also in the criminal complaint, it charges you with a Part 2 that gives notice to the defendant that in addition to the offenses charged, the state of Idaho will seek a sentencing enhancement on Count 1 and Count 2 pursuant to Idaho Code 192520 for the use of a firearm or deadly weapon while committing the offense charged, which may increase the possible sentence for each offense by 15 years. All of those penalties could run consecutively, one after the other, or concurrently at the same time. They could also be enhanced by that Part 2 section of the criminal complaint. Mr. Olison, does your client understand those charges as well as the maximum penalties?
He does, Your Honor.
This matter will be set for a preliminary hearing. Well, first of all, let's just go over counsel. It's my understanding, Mr. Olison, that your client has retained you. Is that correct?
That's correct.
All right. And the state is being represented by Mr. Nye and Ms. Keene. As far as the preliminary hearing, that matter needs to be set within 21 days. It's my understanding there is some conflict with potential witnesses. The court has available for the preliminary hearing January the 7th. We would schedule that at 9 a.m.
That works for the state, Your Honor.
All right, currently have a jury trial scheduled that day.
Right. Mr. Olison, if we are going to be rescheduling this from the 7th, we'll need to do it before then. Potentially we could do the 6th of January. Does that work for you?
depend on how my trial goes. It's scheduled for the 4th, Your Honor.
Okay. We'll plan on January the 6th for a prelim. We'll begin that at 9 a.m. Mr. Olson, if there's some issue, please let us know as soon as possible. In order to honor the rights of your client, to have this within 21 days, it will be requisite to get that done on the 9th. Otherwise, there will need to be, what did we say, 7th? The 6th, sorry. It will need to get done on the 6th. Otherwise, we'll need to talk about a potential waiver of speedy prelim because of those issues. Do you understand?
I've talked to my client about that, Your Honor. He understands his right to have a preliminary hearing within 21 days since he's not in custody, and he is willing to waive those timeframes if necessary.
Any objection to schedule it on the 6th, or do you want to bump it back a little bit further?
Your Honor, I'm just concerned about my schedule. I'd prefer to bump it where I had a clear day so we didn't have to prepare and then potentially not have that. Does the court plan on Thursdays, or are those your days, Your Honor?
I don't really have days dedicated to Bingham County. I'm fairly booked for the next month, but there's a few days that we can potentially make work. One of those is probably December the 28th. January the 28th, I apologize. January the 28th is a Friday.
Your Honor, that day will work for me. I did have a trial, but that is getting resolved, so I do have that day available. It's completely open. I would prefer that day.
Mr. Nye?
Your Honor, that date does not work for one of our witnesses who has a scheduled vacation from January 27th to February 7th.
How about January the 26th?
That would work for this date, Your Honor.
Morning or afternoon, Your Honor?
We would set it in the morning, 9 a.m.
I think that should work, Your Honor. I have a trial schedule, but I think that one's going to be resolved also.
Let's plan on January the 26th. We'll commence at 9 a.m. for the prelim. That will be held here in person at the Bingham County Courthouse. Let's talk about timeframes. Mr. Nye, how many witnesses does the state anticipate?
Your Honor, the state anticipates 3 witnesses. We don't think that it'll take any longer than 2, at most 3 hours.
Mr. Olson, on behalf of the defense.
I will have to get with Mr. Nye and see who he plans on calling, because that will depend on who we would also call. I know there's 8 potential witnesses. Depends on which 3 they're going to call. The other 5 then may be called. So I would plan on at least a half day, if not a full day, based upon what Mr. Nye just stated.
All right, we'll plan on a full day on the 26th. Obviously, if it takes shorter than that, we'll finish up before then. That'll take care of the scheduling of the preliminary hearing. Any other matters from the state here today? I note that there was a no contact order, or several no contact orders that were issued by the court. Any other matters pertaining to those or anything else? Mr. Nye.
Yes, Your Honor. The state is asking for 3 conditions on release, if I could be heard on those now.
Okay, let me open up the file here just one moment. I note that there was a notice of intent to seek conditions on release filed by the state. It's pertaining to that document that was filed on the 22nd. Is that correct?
That's correct, Your Honor. Those are the 3 conditions that we're asking for. Just to briefly summarize those conditions, we would ask for a no contact order be signed for 3 of the minor victims. Now, I know at the last hearing, the court entered a no contact order for all of the victims without kind of definite terms. The state did speak with all of the victims, and the parents of the minor victims discussed no contact orders, and after those discussions, it was 3 of the minor victims who requested those no contact orders. I provided their information to the clerk, and so we would ask that those no contact orders be signed. That's the first condition. The second is we would request that the defendant be required to surrender his firearms to the Idaho State Police or the Idaho Attorney General's office, and that he not possess a firearm for the duration of the case. The third is that we would ask the court require the defendant to take and remain on a leave of absence from his position as Bingham County Sheriff for the duration of the case. Now, as this court knows, the conditions on release are governed by Criminal Rule 46, as well as Idaho Code Section 192904. And in considering whether or not to impose these conditions, the state would ask the court to consider the strength of the state's case here, as well as the likelihood of conviction. As the probable cause affidavit makes clear, there are 8 eyewitness accounts of the defendant's conduct that night. They are not only consistent with each other, they are also corroborated by confessions or admissions that the defendant made to the chief of police in Blackfoot, as well as to an investigator with the Idaho Attorney General's office. On top of that, there is video evidence in this case. Now, the video did not capture the confrontation at the car, but the video does reveal that the defendant saw that these were minor children prior to the confrontation and saw and read the paper thankful turkey that the victims left on his door immediately prior to the confrontation. And after reading the words "thank you" on that turkey, the defendant said, and I'm quoting, "Bullshit, get my gun." Now, that's significant to the state because it shows that the defendant's conduct that night was not based on a misunderstanding, and it was not based on anything that could be characterized as a threat in any way. And so the state is asking for these conditions because any person who responds to that kind of harmless conduct that is well-intentioned on its face by equipping himself with a gun, leaving his property, and initiating an extremely dangerous and potentially deadly confrontation is a risk to public safety, at least so long as he has access to firearms or is serving in a position that is high stakes and high stress and involves firearms like county sheriff. Now, just a final note, Your Honor, another factor listed in 192904 that this court shall consider is ensuring the integrity of the court process. And the state finds it hard to believe that the public would be able to see integrity in this court process if it allows the defendant to remain the chief law enforcement officer of the county while facing these allegations, given the strength of the state's case. And so for those reasons, the state would ask for those conditions, Your Honor.
Thank you, Mr. Nye. Mr. Olson, you wish to be heard?
Well, first of all, Your Honor, I think it should have been noticed out. It was not noticed for today. If the court is going to take it under consideration, then yes, I would like to be heard.
I will take it under consideration. You can argue now.
Your Honor, I strongly disagree with the state's version of the facts. That is apparently their best case scenario. Those are not accurate facts in our opinion. That is the state's interpretation of those facts, or their variation of what they believe are true. However, Your Honor, this case is really interesting. What's interesting to me is how originally I thought that the Attorney General's office was just doing a standard investigation, but as this has progressed, this is not an investigation, this is a political. When the state or the AG's probable cause statement released or put the information in the probable cause statement, which has taken national attention by the comment which was taken out of context in that's gained national attention. It's inflamed the portion of the population, and there was absolutely no basis for that statement to be put in a probable cause statement other than that fact. Thought, well, maybe that was just how they wanted to put their probable cause statement forward. Now, as we can see, based upon their requests, this is clearly political. All the Attorney General is trying to do is try to remove Mr. Rowland from his position, which frankly they have by attempting to do so, they're violating the Idaho Constitution and the statutes. A sheriff can only be removed by certain factors under the Idaho Code provisions and the Constitution. If the Attorney General is attempting to remove Mr. Rowland from that office which he was elected to and place someone else in that position, they are violating Idaho Code 6602. Further, They're making allegations that he should not have a firearm because of this offense or alleged offense. He has the right to have a firearm under our Idaho Constitution that can only be removed upon any conviction of a felony or other certain matters. I think it was also interesting that they are now asking for terms of release at this point in time, which they've never asked for before. He was summoned in, he's cooperated. The whole point of the criminal rules is to ensure that someone either bond or release, they appear in court and the public is protected. There is no risk to the public by Mr. Rowland continuing to exercise his elected position, and the Attorney General should not be violating Idaho Code and Idaho Constitution attempting to have him removed prior to any potential conviction. We don't think they have a strong case. We think he will be acquitted of these charges if it goes past a preliminary hearing. Mr. Rowland was doing his duties as a law enforcement officer as their own probable cause statement indicates. He was acting in his official capacity. And so they're trying to charge a law enforcement officer in his official capacity with crimes using a firearm, which are sometimes, as we all know, used by law enforcement in their official capacity. And we would ask that those terms be denied. Further, Your Honor, as to the no contact order, I don't know specifically which children he's asked for the no contact order against. I personally spoke to every one of their parents yesterday. 3 of the parents absolutely do not want a no contact order. One of the parents, he doesn't care either way. Another parent, he says his legal counsel advised him that it might be a good idea. Only one parent that I spoke to said they wanted a no contact order. So I don't know which ones they're asking for, but I think they need to name those, or at least the initials, or somehow so that I can know who they're saying wanted the no contact order before the court even contemplates granting that. However, Your Honor, there were 3 no contact orders issued before, which we didn't have a problem with initially. I thought it was just going to be 1, but it's interesting how those came out with the different names. And so I'm assuming that based upon that no contact orders that were issued, that is the people that they're wanting to be granted the no contact order. We have 1, I mean, these aren't even numbered, Your Honor, for any purposes, but the 1 no contact order lists 1 child, 2 children, excuse me. That is the parent that said their legal representative said it would be a good idea. This no contact order, I would say with the first initial of K, that parent wants the no contact order. And the third no contact order lists 1, 2, 3, 4 children. And those are the people that said, we don't want one at all. So I'd ask the court to take that into consideration. Only the 1 wants no contact order. This one, his attorney says okay, these say no. And so maybe that's how the Attorney General is requesting on the 3, maybe it's these 3 that were on these 2 no contact orders, because this one should be dismissed based upon what the parents are telling me. Anyway, that's our position, Your Honor.
Thank you, Mr. Olson. Mr. Nye, will you respond to the issue regarding the no contact orders? And then also I'll give you the last word on the conditions.
Sure, Your Honor. I think it helps to take into account how those no contact orders came about. So last week, as the court knows, this had been set for a remote hearing. At that hearing, the state requested that this in-person proceeding be conducted as soon as possible so that the state could request no contact orders for several of the victims. At no point has the state represented that all of the victims wanted no contact orders. I believe the state or the court ordered no contact for all the victims as kind of a stopgap between the hearing last week and today, because the court couldn't hold a hearing because of the defendant's objection. So the state is only asking for the no contact orders for the 3 minor victims whose parents requested them. That's all. Now, Any suggestion that the other parents think this is not a big deal is simply not true. We had multiple parents contact us last night after Mr. Olson called them. I can tell the court at least one of those parents interpreted that conversation as Mr. Olson trying to convince him not to get a no contact order. He clarified his position, which was, I don't think a no contact order is necessary, but if I were with my daughter and we saw the sheriff in public, I would grab her and we would leave immediately no matter the circumstances. So that's where the no contact orders are coming from. On the conditions of release, I do want to be clear. Well, first let me just address the comment that this is somehow political. The probable cause affidavit speaks for itself. And this is not political, nor does that have anything to do with the conditions of release. Second, the removal of firearms. The Idaho Constitution does not protect somebody who has been charged with a crime such as these from having a condition of release that they not possess firearms. That is a standard condition in situations like this. It is not at all unusual for us to be requesting that. Third, as to the sheriff's position, the state is not asking this court to remove the sheriff from that position today. The state is only asking this court to enter as a condition of release, basically to prohibit the sheriff from acting as the Bingham County Sheriff for the duration of this case. Now, one of the options this court has at this hearing would be to order the defendant into custody. The state is not requesting that. But if the court has the authority to do that, certainly it has authority to prohibit the defendant from engaging in that activity. And that authority is clearly spelled out both in Rule 46 as well as Idaho Code 192904. So this court has the authority, and for the reasons that we've already articulated, we would ask the court to do that. Thank you, Your Honor.
Thank you, Mr. Nye. All right, the court has listened carefully to the argument of both parties. It's pretty standard at an initial appearance for conditions of release and or bond, that those are put in place at this juncture of the case. With regards to the no contact orders, here's what the court's going to rule on those. I'm going to rule that inasmuch as one of the alleged victims wants the no contact order, that no contact order will be entered. What I'm going to instruct the state to do is to communicate with each of the alleged victims, find out if they do or don't want the no contact order. If they do request that, the court will enter that. I want the state to communicate with the clerk about which of those names request those, which don't, and then the court will quash the no contact orders that are currently in place for individuals or alleged victims that don't want them. Is that clear, Mr. Knight?
That is clear, Your Honor, and we will do that.
All right. With regards to the request for conditions of release, we've already talked about the no contact orders. The second request was that the defendant be required to surrender any and all firearms while this case is pending. This court is cognizant that it must presume any defendant is innocent until proven guilty. The court is also cognizant that it must treat any defendant as it would in any other case, the same as it would in this case. I recognize that there have been things argued here today about politics or other issues. The court is not concerned with that. The court is concerned with Idaho Criminal Rule 46, and pursuant to subsection E, the court has the ability to enter any requirements of release, pretrial release, and or bail in order to ensure, number one, that the defendant appear for all court appearances, and number two, for the protection of society while this case is pending. And I think that would include the protection of the defendant. The court has listened to the argument of the state, has listened to the argument of Mr. Olson, and the court is going to grant the request from the state. I'm obligated to look at those conditions, to make sure that all of those things are followed. So I will require that the defendant surrender any and all firearms. The state has requested that those firearms be given to the Idaho State Police. That's what the court is going to order here today. Both any firearms that are accessible to the defendant at his employment and or any firearms that are accessible to the defendant at his home. With regards to the request to require the defendant to remain on leave of absence while this case is pending, the court is going to deny that request. Like I said, the court always weighs the fact that the defendant is presumed innocent. The defendant has he has a right to stay on a leave of absence if that's what he wants to do. He also has the right to work. That being said, if he is working, he will be required to abide by all of the conditions of release, including but not limited to that no contact order, including but not limited to not having access to any firearms. That will be the order of the court. I'm also going to require that the defendant appear for all court appearances, maintain contact with his counsel, abide by those no contact orders, and a violation of the pretrial conditions could result in the defendant being incarcerated while this case is pending. Mr. Olson, do you have any questions about my ruling here today on those conditions of release?
Just a couple of things, Your Honor. We will need to have photographs of which children are subject to no contact orders so Mr. Rowland can know who they are. We don't want to have any inadvertent contact. Some of these kids, he doesn't know them. So we need to know who they are, have a picture of them so that he can not go around. Or if he sees them, he can turn around and walk away.
Mr. Olson, I think they have a right to remain anonymous at this juncture, especially because they're juveniles. I'm not saying you can't have the picture, I'm just saying what sort of protections can you give these victims to make sure that doesn't end up in a court file?
Well, the AGs can just give it to us. That's fine. It doesn't need to be in a court file. But I don't want to have him being alleged to have violated when he doesn't know who he's not to be around.
All right.
Because the name doesn't mean anything.
Any objections to the court requiring that if the photographs are shared, that they not be disseminated to anyone beyond the defendant and defendant's counsel? I'm asking you first, Mr. Olson.
Oh, I don't have any problem with that.
Okay. Mr. Knight.
No, Your Honor, the state has no problem with that.
All right. Mr. Olson, any other issues?
Yes, Your Honor. As to his weapons that he has, which have been assigned to him from the county, those are the county's weapons. If the court wants them turned back into the county, that's fine, but I don't think they should go to the state police because they're county weapons.
Mr. Knight.
Your Honor, herein lies the difficulty. If they go to the county, he is the chief law enforcement officer for the county. There's nothing stopping him from ordering someone to give them back to him. So he would still have access to those weapons as long as they're with the county. And so that's part of the reason for that third request. I understand the court has denied that, but we would ask that at the very least, the service weapon that was used that night, which the defendant has admitted he used that night, which is county property, that as well as personal firearms be surrendered to the Idaho State Police.
Mr. Olson, when you say that they should be given to the county, give me an idea of what that means.
Well, he has these service weapons, which was issued to him by Bingham County, okay? So if that needs to go anywhere, it needs to go back to Bingham County.
Okay, so
Bingham County's weapon.
Describe for me what that means. Bingham County's the sheriff's office?
It'd be the sheriff's office. I
And
mean, I think he has. So yeah, he has that service weapon, which is owned by Bingham County, should go back to Bingham County. Weapon should go to Bingham County. I mean, any other weapons that are taken or to be surrendered in any other case, the court would have you order it be surrendered to the sheriff's office or the police department, somewhere local, not go to Boise. So they should be here. Mr. Knight's argument that he could order one of his deputies to give him a weapon, he could do that anyway. He's going to comply with the court's order. He won't have the weapons. He'll turn them over. But they shouldn't go disappear over Nada County in the hole that is over there where people never get anything back. So they should be maintained locally as they would in any other case. If you want to turn it over to the Blackfoot Police Department instead of the sheriff's office, fine.
Mr. Olson, as far as county-issued firearms, is there just one?
Yes.
Mr. Nye, I'll let you respond.
Your Honor, the reason why we chose the Idaho State Police is because the Blackfoot Police Department has requested that they stay out of this case completely. So it was at their request. We don't have a problem with that. If the Blackfoot Police Department doesn't have a problem with that. I would also note that if it's surrendered to the Idaho State Police, we're not suggesting that go to Idaho State Police headquarters in Boise. They have an office in Pocatello as well.
All right, the court has listened carefully to the request and the issue pertaining to where the firearm should be placed while this case is pending. The court is going to stick with its previous order. I will require that those be turned over to the Idaho State Police, both the personal firearms and the firearm that was issued by the county. Mr. Olson, if you want that deposited in the state police office in Pocatello, that's fine, we can honor that request. The state will coordinate with you to make sure that that's what's done. Any other issues, Mr. Olson?
No, Your Honor.
Mr. Nye, any other issues?
No, Your Honor, thank you.
I appreciate the argument of both parties. That'll take care of today's issues. We'll reconvene here at the end of January for the preliminary hearing. We'll be adjourned.
Please rise.